All right, we're ready to begin. We'll call the case of the state versus Ashley Franklin. It's case 25 CF 1152. Appearances, please.
Certified student attorney Joshua Guinnett, spelled G-I-E-N-A-P-P, under the supervision of ADA and Davies.
Ashley Franklin appears in person, along with attorney Michael J. Short. We acknowledge receiving a copy of the criminal complaint. We've waived its reading. The address is correct.
All right, thank you. So it looks like we have a criminal complaint on this possession charge. She was also booked into the jail at the same time on a second offense OWI charge, but I believe she's being released in favor of a court date on June 26th at 8:30 on that part of it. You may have said it, Mr. Short, I don't remember. Is the address the best one to use?
Yes.
All right. And what's the state's position regarding bail?
State recommends a signature bond. Additional conditions that the defendant not consume any alcohol, and also that they not possess or use any controlled substances or possess drug paraphernalia without a valid prescription.
Mr. Short.
No objection.
I'll order a signature bond. I will order the alcohol-related condition. I'm going to decline to order the drug-related condition because it duplicates the law anyway. Obviously, that's not permission for Ms. Franklin to use illicit drugs. It's just a recognition that if she is caught with that, she can be charged with criminal offenses, including bail jumping, just by virtue of the state of the law. What about the time limits for preliminary hearing?
We'll waive the time limits.
Real good. We're going to have some paperwork for you, and then you should be able to be released. You're going to have a couple different court dates coming up, but you and Mr. Short will work through all that, okay? All right, good luck to you.
Franklin,
Thank you.
just
You're
a minute.
welcome.
That's an auto
Next
sign.
we'll do late Spencer, just this one here.
That's an auto sign.
Yep.
It's McNamara and McNamara is. So when they label something before these.
So that's 2512.
Here,
Mm-hmm. Then you can time. And you can time block some stuff on.
Oh, sorry. He's on. I totally fixed that. That's my fault.
I think they're right in.
Oh,
Give or take. So you're gonna do the next one because that's only in 4 days.
oh, yeah.
Okay, so then. We don't need to put anything in here as far as like an attorney, because he's very.
Is there-
we'll be right with you, Mr. Spencer.
It's gonna be a person. But isn't there something?
You don't have to, because we're not doing family.
It's just-
So it's just a normal notice. So we don't have to try and refer to us.
I did not somehow.
Yeah.
You should have everything. We've got conditions. That's much really good. Oh, I gotta change my printer.
You said it.
No, I did not.
No, it's inconsistent down further. Should be good.
Okay, we're good.
All right, I think we're ready to call the case of the state versus Blake Raymond Spencer, case 25 CF 1155. Appearances, please.
Certified student attorney Joshua Guinnett, appearing for the state under the supervision of ADA and Davies.
Attorney Jerry Evans appears on behalf of Mr. Spencer, appears remotely.
Yes, Mr. Spencer, I do want to confirm that you can hear us okay. If so, would you please wave or give us a thumbs up? Or a thumbs up. Thank you. I appreciate that. And Mr. Evans, is that address in Omaha the best one to use for Mr. Spencer?
It is.
Great. And should we list you as, oh, I see you have already filed a notice of retainer, so that was going to be a bad question on my part. What's the state's position regarding bail?
Your Honor, the state recommends cash bail in this case in the amount of $5,000 with additional conditions that the defendant does not operate the motor vehicle and that they not possess or consume alcohol. Your Honor, cashing is appropriate in this case to ensure that the defendant's future appearances in court. The defendant is not a Wisconsin resident in this facing 5th OWI comes with a mandatory minimum sentence. They refused to cooperate during the investigations and her officer report exhibited combative behavior towards officers. If the court is unwilling to impose cash bail, pretrial services seems necessary to the state to ensure the defendant's sobriety.
And Mr. Evans, the defense position, please.
My understanding, Your Honor, is that his prior OWIs are significantly dated by a few years. We're requesting a signature bond. He does reside in Nebraska and have to make his way there, but to make his way back for court. As far as the not operate, we would ask him not operate without a valid license. As far as I know, and as far as he knows, he's still employed and driving is an essential part of his job, and they'd like to be able to continue to work at least while the case is pending.
All right, any response from the state?
No.
Okay. So the complaint alleges an injury crash resulting from Mr. Spencer allegedly crashing into a couple of parked vehicles in a residential neighborhood. I'm inferring from that fact situation that the injuries were not to other individuals, but perhaps himself. He does apparently have the 4 prior convictions. It is correct, as noted by Mr. Evans, that they are dated. The most recent of them is in 2011 as far as a conviction date goes. The most distant one is in 1999. It's certainly good that there aren't priors in the last 14 years or so. There's also, though, reason to be concerned about the stretch of time over which he amassed those 4 and the likelihood of picking up new ones while on bail. That would appear to be a realistic concern given the timing of some of the prior convictions. He doesn't seem to really have any ties to this area, and there is the combative or aggressive posture that was described by the state. I shouldn't overlook the obvious, which is it's an offense that carries mandatory state prison in the event of a conviction. All of that tells me that some cash bail is necessary to assure appearance in court. I don't know that I see pretrial services as a particularly viable option if he doesn't really live around here and lives a couple or 3 states away. That speaks more to the cash bail, but because it means that we really can't have monitoring as a practical matter. So I'm going to set cash bail. I think some amount less than the state's proposal probably could be reasonable. I'll set it here at $3,500. I am going to order that he not operate a motor vehicle and that he not consume any alcohol. I understand the concern about driving or his desire to drive. I'm not unsympathetic to that, but at the same time, I'm sympathetic to the dangers posed by the behaviors alleged in the complaint. Inherently, this is a complaint that alleges an inability to determine when it's safe to drive versus not safe to drive. That's kind of the nature of a 5th offense operating under the influence case. If I didn't say it, I'm going to order the no drinking condition too, of course. Mr. Evans, as you know, bond conditions can always change, and maybe some kind of a monitoring plan while he's in Nebraska or something could put together where there could be some change to that driving order while the case is pending. But for today, I think I wouldn't be doing the right thing if I didn't order those conditions. Do you want a prelim within the next 10 days?
I talked to my client, we will waive the requirement to time limit.
That's fine. Yep. I will accept the waiver of time limits, and I think you're aware that there is also a process for remotely waiving the preliminary hearing itself if that's the choice he wishes to make, but you'll talk with him about that first, of course. Mr. Spencer, good luck to you. I hope things improve, and I appreciate it, counsel.
Thank you.
You're welcome.
And no thoughts?
Okay.
Why don't we call the case of the state versus Amanda Fox? It is case number 25 CF 1151. Appearances, please.
Certified intern Joshua Vina, appearing on behalf of the state under the supervision of a county.
Amanda Fox prepared by attorney William Rakestraw. Ms. Fox is eligible for public defender representation. We are in receipt of her complaint waiting for the reading, and that's it.
All right, very good. It looks like she is in custody on a probation hold stemming from a prior drug case out of Madison County. I don't think there's any reason to assign this case to any particular Dane County judge, so I think the computer can just randomly assign one.
Yep.
Does the state have a position regarding bail?
Yes, Your Honor, the state recommends cash bail in this case, and the amount of about $500. Defendant was on probation at the time of the current offense, and we believe cash bail is necessary to ensure the defense appearance in court. Seems like seems somewhat unwilling to follow court orders. Additional conditions, bond that the defendant not possess consume drugs or drug paraphernalia is recommended.
And Mr. Rakestraw.
Yes, Your Honor, I'm asking for a signature bond, which, I understand the assessment is saying minus cash bail. I believe the signature bond is appropriate here. So my understanding she's on a probation hold. She is currently on probation. My understanding the hold has been lifted. This is an incident of, yes, it appears drug possession. This was not a situation where Ms. Fox was out seeing, at least according to the complaint, wasn't out in the public atmosphere with these drugs. They were at a house. They were at her residence. So I do not believe cash bail is appropriate here. Again, she's on probation. If they want to revoke her, they can revoke her. It seems that they're not doing that based on this, but she is under supervision already.
Any response from the state?
There.
Okay. And the printed version of the booking sheet I have from earlier today had the whole listed. The online locator now says it has been dropped.
I was just supportive of divide this box right now.
Right, so it must have changed throughout the course of the day today, and I think you're right about that. The PSA does recommend modest cash bail. It also puts it right about at the middle in terms of risk of new criminal activity and or failure to appear. It's a possessory drug offense. I should take a little bit closer look at the complaint, but I don't recall information suggesting that she was uncooperative or fled or any of the things that would cause one to also be concerned about appearance in court. Yeah, I don't see anything like that in there. I think a signature bond is reasonable here. I'll adopt a signature bond. I'll not set the drug related condition because it's the law. It's almost certainly a probation condition, and the complaint itself is evidence that there can be a criminal justice system response if there were to be a violation of that. What about the time limits for preliminary hearing? We'll wait. Okay, that sounds fine. I think you're going to be able to be released today. Your ability to stay out, of course, depends on you probably staying away from drugs and things going well while you're out. I hope it does work out for you. Take care. You're welcome.
When we're ready, we'll do Demetrius O'Kelly will be appearing by Zoom, but yeah.
Just 1 minute. Okay. Yes.
Okay. So we'll do
Mr.
Demetrius
O'Kelly.
O'Kelly
Okay.
by Zoom from meeting.
Thank you. We'll call the case of the state versus Demetrius O'Kelly. It is case number 25 CF 1154. Appearances, please.
Cameron Davies, the state of Wisconsin.
Demetrius O'Kelly appears by attorney William Rakestraw. At this time, the public defender's office has not determined eligibility for Mr. O'Kelly, so if released or if custody release, contact our office so that we can do that. We are in receipt of the criminal complaint, waiting for reading here. Please look not to.
All right, thanks. And I do see Mr. Kelly's there at the window, looking and listening. Mr. O'Kelly does have 6 open misdemeanor cases assigned to Judge Kondar. The most recent 4, I believe, are in a status where the issue of competency was raised, and it looks like we're waiting on an evaluation report. There were cash bails posted in some of those cases as well. Well, let's start with the state for its position on how to proceed and any bail requests.
Sure. Without knowing the ins and outs of those other open cases or the detail of Mr. O'Kelly's mental state, I'll defer to the court. I guess potentially extending counsel with regards to that. I don't think I'm in a position to necessarily do anything there. With regards to cash bail, the state would be recommending full bail conditions as well as cash bail. In this case, the state will be requesting $2,500 cash bail, along with non-monetary conditions like the defendant first have no contact with Jerry J. Jerry is spelled with a J. The state is also requesting the defendant be banned from all Madison Metro buses and bus stops. With regards to cash bail, this is now the defendant's seventh pending case. By my pretty cursory review, so going on the record here, I think it's also pretty substantially his most serious case. It involves violent accusation. It involves what I believe is an act of reoffense. It's obviously a felony matter. It is putting individuals in Madison at risk. The defendant also about 2 weeks ago, I think 2 weeks ago today, was able to post $500 cash bail and was released from custody. And now is again escalating behavior, adding new exposure, putting the public at risk. So the state does believe that substantial jump of cash bail is appropriate at this time.
All right, and Mr. Rakestraw?
Yes, Your Honor, in regards to the competency, I leave it to the court to determine how they want to proceed with competency. I have not, my office is speaking with Mr. O'Kelly, but it's my understanding that competency order smart was put in place for him in his other cases. So I leave it up to the court to determine whether they're going to connect here as well, or let's proceed forward until he gets with other folks, with the actual court who will hear this case, Your Honor. As to bail, Your Honor, I would ask for a signature bond as what's recommended on the public safety assessment. As but I understand that he does have a number of open cases that actually was passed. He was able to post that. However, I don't believe $500 is necessary here. I would ask for signature bond if the court feels cash is necessary. I would ask for cash in the amount of $200, Your Honor.
Anything else from the state?
No, not at this time.
Okay, I have reviewed the allegations in the complaint. I very briefly reviewed the other pending cases. By my math, he's posted just over $1,000. And when I say he, I don't know whether it was he personally or whether it was the community at large. There's some reasons to think that bond in those cases was posted by basically complete strangers. That's relevant to the effect that bond would have on compliance, and maybe that's that concern is realized by what's alleged in this complaint, which is an allegation of battering a bus driver, and at least according to the complaint, what would be a completely unprovoked manner. It's an Act 3 case. There's an allegation of resisting an officer. He's just had an absurd number of open cases at this time, and with the unresolved competency issues, there's the remaining question, I suppose, about ability to comply and whether bail conditions would be effective to prevent new law violations and to preserve the safety of the community. I'm not going to set cash bail here at anything less than $5,000. I'll set it at that amount. I'm going to order that he not be on any Madison Metro bus, at any Madison Metro bus stop or transfer point or transfer station. I'll also order that he not have contact with Jeremy J., who I think is the bus driver that's alleged to be the other party or victim involved in this case. I think for the sake of consistency and given the behavior described in the complaint, there's reason to doubt competence. I'll make a finding that there's reason to doubt competence and direct that an evaluation be conducted. A hearing is already scheduled on the misdemeanor cases in front of Judge Kondar, though I think that's in her capacity as the trial judge. Our local court rule would sort of suggest that we would have to get this at least initially set up for a return date on the competency hearing in front of the commissioner. I think that could change in the future in this case, but for now, let's use a commissioner level competency hearing return date as a placeholder. All right, Mr. O'Kelly, I hope things begin to get better for you, and hopefully we can get some answers soon to how best these cases should move forward.
Your Honor, before we go off the record, and the court may have more information than frankly I do within my system with probable cause and things of that nature. The state's request was for a no contact with Jerry J. Jerry. Obviously that could be short for Jeremy, but I just wanted to make sure that the correct name is listed.
Your name is correct. I wasn't properly reading my own writing when I said it out loud earlier. Okay. Jerry J is the right name, and I appreciate the correction.
Multiple.
We're doing all the cases of the state of Wisconsin versus developed vendors. They're cases 24 CM 876, 25 CF 81, 25 CF 169, and 25 CF 202. May we have appearances, please?
Cameron Davies for the state of Wisconsin.
Camilla Colbert appears by attorney Lee Rakestraw. Ms. Colbert is eligible for public plaintiff representation. We are in receipt of the criminal complaint, waive the formal reading, and enter pleas not guilty to any misdemeanors.
All right, thank you. These cases are each in somewhat different procedural postures. Case 24 CM 876 is here on return of a bench warrant that was issued by Judge Schlipper on April 21st after a missed plea and sentencing hearing. It looks like there had been a $500 cash bail posted in that case following an earlier warrant. I don't see that anyone sought forfeiture of that bail, and I think it remains on file. Case 25 CF 81 requires an initial appearance. We're here on return of a warrant after there was a missed initial appearance there. 25 CF 169 has a similar posture as the last case I just described. And then 25 CF 202, it looks like it does as well. So maybe only a couple different postures. The new cases will be assigned to Judge Schlipper pursuant to local court rule. What's the state's position regarding bail on these matters?
Sure. So beginning with case 25 CF 81, the state will be requesting $1,500 cash bail, along with non-monetary conditions that the defendant first be banned from West Town Mall. Second, that you have no contact with all co-defendants in that case. For reference, they are Nakaya D. Bull, Ashanti M. Freeman, Jayla J. Green, Jemiah B. Robinson, and Kenesha N. L. Wright. Case 25 CF 169, the state will be requesting $1,000 cash bail, along with the sole non-monetary condition of the defendant to be banned from all AV locations. In case 25 CF 202, the state will be requesting $2,500 cash bail with the sole monetary condition that the defendant not operate a motor vehicle. With regards to the case we're here for a bail bond hearing on 24 CF 876, I'll ask for $1,000 in that case. I'll start by noting with that case that, as Your Honor mentioned, the defendant here missed the resolution of that case. This is the sentence that obviously serves the state with regards to moving forward now that she has 3 new open felony cases, which we will miss the end of that case with a misdemeanor. That certainly doesn't bode well for new felony cases. I'll note, obviously, the fact that we have 3 new felony cases as well as the allegations as outlined in 25 CF 202 are extremely serious. Obviously, that's a fleeing case. Also gives the state pause in regards to the defendant's willingness to work with law enforcement, and take accountability for her actions. I also note that my notes indicate that the defendant has 3 prior fleeing and eluding convictions. Another flee and elude was dismissed and read in a case. There was also a charge on Washtenaw County. Looks like my office looked into that. That case was dismissed, but it was dismissed due to a destruction of evidence. Obviously weighs less against the defendant than the convictions, but it's worth noting that this is obviously a repeat behavior from the defendant. We're also looking at a pretty significant history of bench warrants being issued. I'm seeing bench warrants issued in case 21 CF 2059, February 14th of 2022. That specific bench warrant was not served until August 30th of 2023. We had another bench warrant that issued August 1st of 2024. Bench warrant issued April 22nd of 2025. That's obviously the one that we're here now on. I would also note, and this seems to be a recurring issue with a couple of these new cases, was that the defendant had an initial appearance scheduled for January 23rd of this year. Her attorney contacted the court, let them know that the defendant apparently, according to my notes, had 6 child. They rescheduled for 1 week later. The defendant then did not appear and has not appeared on those cases until today, finally having that initial appearance. So I think that there's a pretty clear disregard for court orders. I think there's a pretty clear disregard for law enforcement. I think there's growing exposure, which again, the defendant was unwilling to show up for a police sentence in a misdemeanor case. I struggle to think what her willingness would be to show up now that she has still that misdemeanor case, as well as 3 new felony cases with some pretty serious, at least one pretty serious charge based on my first degree. I'm trying to balance out 4 cases here. The state does believe that substantial cash bail across these cases is essential to assure that the defendant voluntarily appears in court.
And I overlooked earlier that the booking sheet said that she is in custody and absconder warrant as well. Mr. Rakestraw, any position?
Yes, Your Honor. As to the case where we're here for the return of warrant, it's my understanding that this over missed due to the fact that her was sick. She turned herself in, is my understanding. So this was not something where she got picked up by police. She turned herself in, which I believe is she should receive credit for. As to 3 new cases, Your Honor, for the fleeing case, I would ask for cash bail in the amount of $1,000. For the other 2 cases, I would ask for cash bail in the amount of $250 each, for a total of $1,500. Your Honor, I do that with the understanding that I understand her open cases. She does have a hold, and I understand her recent criminal history. As to why some cash bail is appropriate here, but I do not believe substantial cash bail is necessary. I do believe $1,500 is more than enough to secure her appearance. Obviously, she's got her own hold dealing with her signing status, but I do believe $1,500 is enough to warrant, especially considering the fact she turned herself in.
Let's talk a little bit more about that. Did she turn herself in for the earlier missed court appearance, or one of them that he described, or recently in response to these various moments?
Your Honor, she turned herself in on Tuesday for all of her cases. She knew about her warrants and both the arrest warrants and the bench.
Okay, and I guess I'm trying to figure out what that looked like. Did she come to the jail, go to the police department, do something else? No, I'm trying to figure out what that looked like, to turn yourself in, like whether it was at the police department or you're in the jail or.
She turned herself in at the next police department. As my understanding, she been in contact with her probation.
I need a second to look something up there. Well, the booking sheet says she was arrested at 2810 Coho Street, which my friend Google says is the Baymont Inn and Suites.
My apologies, Your Honor. This is what was on the sheet that was given to me that she had turned herself in, but my understanding she had not turned herself. She went to the hotel. She had been in contact with her patient.
All right. Well, unfortunately, her agent had an outstanding absconder warrant for her, and that's not a big surprise given all of the rest of what's described in these complaints and the missed court appearances. The state effectively seeks an increase in bond from her prior status by $5,500. I'm going to adopt that, but I'm going to structure it slightly different. On the eluding card, which is case 202, with 3 prior eluding offenses, I think it's probably give the set bail at $4,000, but I'll do that. I'll set that with a condition that she not operate a motor vehicle. The remaining cases, I'll set cash bail at $500 on each case. The 2 other new felony cases are at their core retail theft charges, so not the world's most serious offenses. And then with respect to the bench warrant return, I guess I'll take my lead from the state and Judge Schlipper and not forfeiting bail that was previously posted. And I'll just allow her to be released in connection with that case alone on the previously posted $500 cash bail. So, and I'll continue any previously imposed conditions in that older case and the new ones. I think the conditions requested by the state were all reasonable and tied to what's alleged in those complaints. I'll adopt them. I assume we should put out a prelim right away for it.
That's correct, Your Honor.
All right, we'll do that. Good luck to you, Ms. Cover. Take care.
We need just a minute.
Oh, yeah.
So this is the bond.
So if we feel you don't have to
What's the best way to pronounce your first name? Cinia, okay, thank you. Let's call the case of the bail hearing for Cinia Alexander, case 25 GF 37020. Appearances, please.
Cameron Davies, from the state of Wisconsin.
Cindy Alexander, appeared by attorney William Rakestraw. Ms. Alexander is eligible for public defender representation. Me and Ms. Alexander are in receipt of, well, there is no complaint as there's no case number 2, this, but we are in receipt of the probable cause statement and waive the formal review at this time.
All right, thank you. As noted by Mr. Rakestraw, Ms. Alexander was taken into custody. There is not yet a criminal complaint. Looks like the custody occurred on the afternoon of May 13th at about 12:24 p.m. A probable cause affidavit was reviewed by Commissioner Catnaugh. Probable cause was found for charges of first-degree recklessly endangering safety, possession or receipt of a stolen firearm, and possession of a firearm by an adjudicated delinquent. Maybe let's can fill us in on what's happening with a charging instrument and any bail requests.
Yes, Your Honor. So the state will be, I won't bear the lead, the state will be requesting cash bail in this case. I think it might make sense for scheduling to wait for after arguments because the state is prepared to have a criminal complaint ready by tomorrow for an in custody initial appearance. Although obviously should a signature bond be ordered, that would change that type of calculus. But I can say at earliest the state can be ready. So tomorrow, my understanding is that we simply do not proceed to the reports until extremely recently. We're not in complaint, but the state will be ready by tomorrow. With regards to bail recommendations, the state will be requesting $7,500 cash bail, along with non-monetary conditions that the defendant first have no contact with Andrea R, spelled ANDREA, or any member of her family. State is further requesting that the defendant not use or possess any dangerous weapons, as that term is defined by statute. That the defendant be banned from the 300 block of Sweetgrass Drive. Sweetgrass is one word. The state is also requesting a ban from the 1 block radius of 300 block of Sweetgrass Drive. Not sure the practicality of that, but it's a man, so I will make that request on behalf of the state. With regards to the purpose of cash bail, obviously we do only have the probable cause affidavit, but it's not less concerning. It involves a firearm. The defendant does have a prior CCW conviction that was amended initially from felon in possession charge. I bring that up not necessarily for the substance of the felon in possession, but simply to note for the court that the defendant was clearly aware that she was not to possess a firearm and not only possessed one, but endangered the victim in this case. Looks like the defendant is facing some pretty serious charges. While that has not been determined yet, it does make the state concerned about appearance being in court as well as protection of public. Looks like all of the referred crimes are felonies, so at this time the state does believe that cash bail appropriate and $7,500 is appropriate.
Thank you, and Mr. Rakestraw.
Yes, Your Honor. I would note that the safety assessment represents a signature bond on this, and I do believe we're kind of here a little prematurely as an actual charge is going to file in the form of a complaint, but I understand the probable cause statement. I understand the assessment is requesting a signature bond, Your Honor. I expect that not to be the case based off what's in the probable cause statement. So I would make a recommendation to the court of cash bail about $1,000. I think that is more than enough to observe Ms. Alexander's presence in court. She's never missed court before, at least not from the assessment. She's never had any sort of violent charges previous to this one. She has strong ties to the community. Her family lives here, Your Honor. And as Mom said, she was formerly employed in Forest Place. She attends MATC. Your Honor, I do believe, I do understand why some cash bail is probably appropriate, but I believe only $1,000 is appropriate, taking into account her lack of a record similar of this nature, but also at the same time recognizing the seriousness of the allegations here.
Anything else from the state?
No, I don't.
I have had an opportunity to review the Riverside affidavit or the probable cause affidavit. It is fairly detailed as these kind of statements go, which means I have a little bit more information than I might in many cases where there's not yet a complaint. Of course, it doesn't contain all of the information that a complaint might. And I also don't, not to overstate it, but I don't have a complaint. So I don't know at this point what the charges are going to be. That might be part of the deal, is that right now the state's trying to evaluate where charges would be proper or what they think they can prove. The Riverside affidavit seemingly contains a confession to certain of the offenses that are listed on the probable cause affidavit, though likely not the most serious one that's under consideration. There is an allegation in the affidavit of her initially attempting to hide the firearm. There's also information in there suggesting that after being stopped, she was quite cooperative with respect to the recovery of it, and provided a statement regarding some of the behaviors. I think this is kind of a case where the answer's in between based on what we have right now. I think I'm obligated to set some cash bail in this case in order to assure appearance in court. I do that recognizing what appears to be very clear evidence of, within the parameters of the probable cause affidavit, of course, regarding the possessory type offenses. There's more ambiguity, of course, as to what happened and what's going to be charged and what's alleged as to the more serious offense. I'll set cash bail here at $5,000. I am going to order that she not have contact with Andrea R., that she have no contact with Andrea R.'s immediate family, that she not be armed with any dangerous weapons. I'll order that she not be on Sweetgrass Drive in the city of Sunbury. I don't know if that's exactly a 1 block radius. It's probably the bail hearing again tomorrow afternoon. If Ms. Alexander remains in custody at that point, that would become an initial appearance. There'd be a complaint. Depending on what this charge and what that complaint looks like, this bail could change up, down, or stay the same, depending on those circumstances. We'll look at that at that time. I do have to set a court date in the event that she were both between now and then. And why don't we put that on for an initial appearance on, well, why not Monday the 19th at 8:30 if she posts out. So worst case scenario for you today is that if you can't post the bail, you're going to be back here tomorrow and we're going to talk about it again. We'll look at this again, hopefully with a lot more information on both sides. If you are able to post the bail, you can be released right away. You would then have court Monday morning over at the courthouse. And we'll give you all this in writing too. I hope things begin to get better for you. Good luck.
We'll go ahead and set it, but we're gonna set it.
Next, we'll do Dominique.
Yes.
Dominique.
There's 3 of these.
All right, we'll call the case. This is Dominique Coleman. Their case is 25 CF 1127, 1128, and 1150. Appearances, please.
Certified intern Joshua Zena for the state under the supervision of ADA Cameron Davies.
Dane County appears by attorney William Rakestraw, who's Coleman is eligible for public defender representation. We are in receipt of the criminal complaints, waiting for reading, enter pleas of not guilty for all misdemeanors.
Okay, thank you. The complaints suggest that there may be pending cases. Let me just find out where best to assign the case to.
Highland.
Yeah, looks like there are 3. I'm sorry, 4 pending felony cases assigned to Judge Highland. There's also a misdemeanor case assigned to him. So this case, or these 2 cases, should be assigned to that same judge. Does the state have a position regarding bail on these matters?
Yes, Your Honor. The state would use cash bail as appropriate. In the amount of $750 spread over these 3 cases. The defendant previously was had a bench warrant put out for them after a failure to appear on September 26th of 2024. She also is subject to a lifetime revocation, yet these 3 cases, she has violated the condition of not to operate a motor vehicle. So, state release cash bail is appropriate. We asked for $250 and we asked for an additional condition that did not operate a motor vehicle.
And I suppose we can go through the cases, but any information about what she's posted, if anything, in the other case?
One
Yeah. A quick look would say at least $2,000 in case 23 CF 1030.
I believe that's it.
That's what my notes have too.
Okay. And it sounds like Mr. Rickster, you were going through them and that's the only one where there's cash.
Yes, that's what I'm saying.
Okay. And the state's position was $750 total or $750 on each case?
$750 total, Your Honor.
Mr. Rickster?
Yes, Your Honor, I'm gonna request a signature bond for my client. I understand that, she is, at least alleged to have violated her rules of bail, for 4 prior cases, but these do not appear to be scenarios where, there is significant or violent behavior going on that appears, she's just driving the car. I don't know if that warrants a cash bail response. It's my understanding that she did miss court, but she's made it up. She's been making her appearance in court. I think there's 1 miss in 2 years or something of that nature. But she's been making all of her court appearances, Your Honor. She obviously has strong ties to the community. She's not a flag risk. She lives here. She has 3 children live here. She's attending an ATC, Your Honor. She was formerly employed at St. Mary's, so I'm not really sure flag risk. I understand that, and I've spoken with Ms. Coleman and explained to her that she's not allowed to drive a car. But I do not believe that warrants cash bail, Your Honor, and that's why I'm requesting today's signature bond on all cases.
I gotta tell you, I'm not likely to follow either of those recommendations, but perhaps either party has more you want to add regarding that.
No, Your Honor, just, I agree with the defense that there doesn't seem to be violent behavior here, but there is evidence to suggest that the defendant might have a problem complying with court orders, which would leads to risk of non-appearance that like mitigate that.
And anything else, Mr. Rickster?
Your Honor, if you are thinking about giving cash bails, where you're going with this, I would ask that you keep in mind that Ms. Coleman is public figure eligible indigent, and try and keep the bail as low as you can.
Sure, and I always have an obligation to try to set that at the lowest amount necessary to achieve the statutory goals. What we know is that however many, it's a significant number of pending cases, including multiple felony OWI cases with signed bond conditions agreeing not to drive. And one of those cases having $2,000 pledged as part of the promise not to drive has been apparently completely ineffective to prevent her from driving. It's not as though they're just completely sort of technical violations because of some old driver's license status issue. She has multiple pending OWI cases, including a 5th offense OWI that carries mandatory prison if she's convicted, a 4th with a minor passenger allegation. The driving records says that her license is revoked for prior dangerous driving type behaviors. It's not like it's an unpaid ticket or something like that. And the 2 new complaints just sort of suggest she just doesn't give a darn about following the conditions of bond. The complaint in case 25 CF 1128 makes that very plain, where she's quoted as telling the officer who stopped her, quote, "I can drive if I want to, I don't care." And that, quote, "she doesn't stand for a loss," end quote, when she gets stopped for driving, which the officer took as indicating she would continue to violate her bail conditions and the conditions set by the courts and drive her vehicle freely when she chose to. That last phrase is not her phrase, it's the characterization in the complaint based on what she told the officer. nothing else we've done has seemed to be effective to keep her from violating the law in this respect. I'm not setting anything less than $1,000 on each case here. That's in total across these three cases, not much more than she posted on the last case, and maybe that'll get her to start caring about following these bail conditions. She'll have conditions to bond in each of these cases not to operate a motor vehicle, and we'll get them all scheduled for a prelim within the next 10 days.
Our next one, when we are ready, will be Curtis Berry.
All right, now I think we're ready to get rolling again.
Come over here, stand there on the yellow eyes.
Mr. Berry is going to be, I have names.
All right, let's call the case of the state versus Curtis Berry. It's case 25 CM 1076. Appearances, please.
State appears by certified intern Abigail Contract under the supervision of ADA Karen.
Curtis Berry appears by attorney William Raystrom. Mr. Berry is eligible for current independent representation. We are receiving a criminal complaint, waiting for reading, and enter pleas and not guilty.
All right, thank you. Mr. Berry had been on a hold. It has since been lifted, but that involves a case that had been handled by Judge Nosistoon as part of a treatment court disposition, but the local court rule says that in that situation, we're supposed to assign the new case to the judge that was originally assigned to the matter before treatment court, which I believe in this particular case was Judge Genovese. No, it was actually Judge Genovese and then got transferred to Judge McNamara. I know that's confusing, but the bottom line is we got to get the case sent to Judge McNamara. Well, what's the state's position regarding bail?
State requests a signature bond with non-monetary conditions that there's no contact with Sawyer L, Sheila L, Sheila spelled SHEILA, or Gregory M, as well as no acts or threat of violence against Shelley B or Thomas B, he is a boy, as well as no alcohol consumption.
All right, and Mr. Raystrom.
No objection, Your Honor.
I'll order a signature bond with those conditions, specifically not to have contact with Sawyer L, Sheila L, or Gregory M, to not engage in threats or acts of violence towards the other two individuals, and then to not consume any alcohol. Mr. Berry, your hold's been lifted, so I think you'll be able to be released today, and I hope it all works out for you. Take care.
I'm getting my.
Well, glad to hear it. I hope everything works. Take care.
Court calls the case, People versus Cedric Johnson.
Your Honor.
Morning, Your Honor. Edward Drugas on behalf of Cedric Johnson.
All right. Your name, sir?
Cedric Johnson.
All right.
At this time, we'd like to set this for a preliminary examination.
All right, he does have the bond violation.
For the new case.
Well, is there another case coming?
There's another case that he's got
Pardon?
he has a misdemeanor charge that came through from that was the bond violation in this case.
This is the one where he is a double contact.
That's correct, Your Honor. There's a misdemeanor count of DV in 1482.
But that's not considered a violation of this one?
No, it is, Your Honor. He was arraigned on that case on 5/12.
We just did an arraignment last week to get this date. Or was it when was our arraignment?
It was on
the arraignment was on Monday this week. And he got this PCC date to go in front of you.
Right, but there's a bond violation, is what I'm indicating.
If the court has it. I mean, I'm in receipt of understanding that there's a new case that I would anticipate being that bond violation. Because he wasn't.
Well, I don't know that. He was arraigned on a
He also failed.
bond violation.
He failed to show up at the exam.
That case is the bond violation.
Okay. Well, what am I gonna do with the bond violation at this point? I mean,
It's difficult to address if he's got a pending case. And
Well, at this point, his bond is revoked in any event, so it's gonna be revoked. You want this set for preliminary examination? Why is this one listed before me? Was this my case? No.
it was previously,
Set before,
yes, it was an exam that was set. And
that's what I thought.
failed
It was
to-
set before me.
yeah, he did turn himself in last Sunday. He had the mix up of the court.
So
date.
all discovery is complete.
Yes, Your Honor.
People have their witnesses available. My next date is June 3rd. Preliminary examination will be set June 3rd, 2025, 9 a.m. That's before me. All right. Thank you.
Thank you.
Court calls the case People versus Danielle Landeman.
Carolyn Foster Tucker on behalf of Danielle Lampman. You state your name? Danielle Lampman.
Thank you. Yes. All right. Record should reflect we had a bench conference. What are we doing on this case?
Your Honor, we're requesting a preliminary exam.
And all discovery is complete.
To my knowledge.
People have their witnesses available the 27th. Preliminary examination in person, May 27th, 2025. 9 a.m. That's before Judge Washington. I will also execute an order that defendant, to the extent we can, her mail privileges, her ability to send mail will be restricted. I'm just not sure how that's gonna look. But we're gonna shut down her potential communication with the alleged victim in this case the best way we can. All right. Thank you. I'm gonna need an order that says that kind of. Why are you up here at my, why are you at my podium? Why are you at my podium? Next time, Tana, turn your phone up louder when that's going on. Did I call your case?
Yes, you did. You called, Mr. Babb, Marquise Babb.
Oh, that was so long ago. You're right. You are right, Miss Cannon. And I usually criticize you for not getting up here on time. And I have to give you credit that you're like early.
Got it, Judge.
Court calls the case, People State of Michigan versus Babb.
That is on behalf of the people, Your Honor.
Stephanie Cannon on behalf of Mr. Babb, who should be appearing by Zoom. Oh, thank God.
Mr. Babb?
Please be there. So what had happened?
Marquise Babb, you need to unmute and turn on your camera. Every week, Cannon. Every week.
I was doing my part today. Your Honor, we're
This
just
is
setting
gonna
it
be
for a
just one of
preliminary
those
exam.
days. What?
We're simply setting it for the preliminary exam.
I gotta have him, I don't know who, I gotta have him here. Oh, you're just gonna call him?
Yep. Yep.
Never mind. I'm gonna say something. This is practicing law by janaza. That's what you're doing right now. This is,
Great, he got it.
yes, I can relate. This is so you. You're like, what? Oh, uh-oh. Mr. Babb?
Yes, sir, Judge.
All right, you got your camera on?
You need the camera as well?
Yes, yes, Mr. Babb.
That is his camera on.
Yes, it's already.
Is that Mr. Babb?
That's Mr. Babb, Your Honor, yes. The good news is he'll be here in person the next time, Your Honor.
I won't be here to witness it. It's going to somebody else. All right. All discovery is complete, Ms. King.
Yes, Your Honor. Discovery is
People
complete.
have their witnesses available the 27th. Preliminary examination in person, May 27th, 2025, 9 a.m. That's before Judge Fresh Hour.
Thank you so much, Your Honor.
Thank you. Bond will continue. Court calls case of the people versus Marvin Sullivan.
Andrew Childers appearing on behalf of you.
James Fifelsky appearing on behalf of Mr. Sullivan, who is approaching. State your name for the judge, please.
Marvin Sullivan. Thank you.
Your Honor, this is a first PCC. I'm asking for an adjournment for discovery and investigation. So I can review discovery with my client, and if I could possibly address bond, I would appreciate it.
Probable cause conference, May 29th, 2025, 9 a.m. I need a screen sheet.
Your Honor, I know you hate it when I do this, but I actually have a trial in Wayne County that day. Could we do the 3 weeks out?
June 5th.
Thank you very much, Your Honor.
2025, 9 a.m. Esteban.
Your Honor, it's my understanding a $10,000 bond has been set in this case. My client has a lot of family in and around Romulus. He would reside with his mother in Romulus if he were bonded out. Has been gainfully employed doing demolition work out in Detroit, has 3 kids, custody of, I think, 2 that are in Michigan. And to my knowledge, I haven't had a chance to verify this, but it does not have any prior convictions involving firearms or assaultive activity. And I believe that while he has another pending case, that case has a PR bond. So I would ask the court to consider a low cash bond.
What's his other pending case?
No.
I'm not sure.
They got up to driving without ops on the person.
Maybe a misdemeanor case.
So he's got another weapon charge.
Apparently so. I don't know anything about it, but it has a PR bond, so.
But that case preceded this one. And then he picks up this one.
I don't know.
Actually, the other case that he has here is the other issue is that the defendant does have an extradition warrant from Mississippi. And we haven't, and I did verify, I spoke with Ms. Burton Harris yesterday about this in our office. We're awaiting the actual governor's warrant in Mississippi, but we can verify that there is a warrant for an out of Mississippi,
but we don't have the governor's warrant yet.
Correct. And so there is a CCW, Mr. Sullivan has a pending CCW charge now, 8/27/2022. And then the facts of this case have been in the fall, so that the older CCW, which is still pending, predated this offense. Mr. Sullivan does have a prior CCW conviction under HIDA, 2012. And obviously this case involved possession of firearm and shooting it in the vicinity of a Washington County Sheriff's deputy who was training canine in the back of the parking lot. It's not charged with, he wasn't charged with shooting at that deputy, but the reason this came to law enforcement's attention was the deputy was training his dog, heard gunshots and saw a car drive off. And our allegation is that if Mr. Sullivan was shooting, basically testing out his new gun that he shouldn't possess in the vicinity of the deputy. I'd ask the bond, frankly, the $10,000 bond.
But it's
seems
low.
Low.
Anything else?
Nothing further, Your Honor.
Didn't think so. Bond denied, most of the bond reduction is denied. Bond will continue. Thank you.
I'm done. Thank you, Your Honor.
Court does call the case of the people versus Winona Harvey.
Harvey.
Morning, Your Honor. Hannah Mack, requesting permission to practice under Michigan Court Rule 8.120 under Public Defender Brian Bowling.
Permission to practice is granted. Good morning.
Thank you, Your Honor.
All right. Ms. Harvey, can you state your name?
No, I can't. I know, you got, my last name is Michelle. Where are you? Where are you?
I met with you in jail yesterday.
Look, if it's gonna skip, okay, yeah, okay.
All right. You're Miss Harvey?
Yeah.
Okay. You're seeking an adjournment?
I am, Your Honor.
Oh, no, I'm not Miss Harvey. People don't miss Harvey. I'm Harvey. I'm Harvey like that. People don't miss me, but I'm Harvey.
Okay, then maybe she doesn't want to be addressed as a Mrs.
Understood.
I know miss. People don't misses me or nothing. I'm the Harvey.
Sorry about that.
My apologies.
Okay.
Probable cause conference will be adjourned June 5th, 2025. 9 a.m. Bond continue.
We'll be in touch, Harvey, okay?
When?
I'll come
Excuse
visit
me,
you.
what's going on?
We just adjourned your case. Winona, remember we spoke yesterday and you said
Until when?
Which date did you get?
June 5th.
Thank you.
June
Sorry.
5th, you want to see me?
No, I'm going to see you before then.
Look, I'm not going back. I can't go back to the conference room. That hurt my back a lot. That room you took me and hurt my back a lot.
Okay. I'm gonna let you talk to your attorney some other place, okay?
Okay,
Thank you. Shut her, please. Court calls the cases of the people versus Dale Miller, 3 cases.
And Maggie on behalf of Mr. Miller, who is approaching. Please state your name for the record.
Dale Miller.
Your Honor, we recently have received a competency report and we stipulate to findings of Mr. Miller being incompetent but restorable.
They've determined that he's incompetent, to stand trial at this time, but likely to obtain competency through treatment. Is that correct?
Yes, Your Honor.
All right, I have reviewed that report. I will sign off on those orders. I'll set a competency review hearing. I need 90.
90 days would be August 14th.
August 14, 2025, 9 a.m. Defendant's bond will continue.
Right. Thank you, Your Honor.
Thank you. Court does call the case of the people versus Martez Dalton.
Hannah Mackey on behalf of Mr. Dalton, who is, I believe he's riding a bus right now to court, Your Honor. The last we've heard, he was in downtown Ann Arbor 20 minutes ago. It's a slow bus.
No, he came from Detroit. Let him know he came from Detroit.
The bus has been driving from Detroit, Your Honor. Maybe it ran out of gas.
You ran out of, what?
He's coming. The bus is coming.
How do I know he's on a bus?
I spoke to him, Your Honor.
Huh?
I spoke to him and he said he was on the bus.
So what do you want me to do? Bench warrant him?
No, Your
And
Honor.
we can go get him?
If you could please pass this matter for a few.
A few. Okay, so hold on. I went through this almost exact same thing with Cannon. And yes, I know, they had pictures all along of him on his bus ride. It was
So
like
it's the
trees.
common
It was
thing.
video. It was just trees going by a window on a bus. I don't know if it was on a bus. But at least they gave me pictures. Not you, nothing.
I'll provide photos, Your Honor, in a minute. It's clearly a common problem with buses. If Stephanie had the same issue with her.
Okay, Mackie, when's the last time you got on a bus?
For school, Your Honor. We ride a bus from the parking lot to class. It's like a mile walk.
When's the last time you got on a bus for travel around the city or?
New York. In New York. Subway, that's even better. Subway.
A subway is different than a bus.
Okay, I've never been on a bus, Your Honor.
I didn't think so. Okay, thank you. I'll pass it.
Thank you, Your Honor.
I've never been on a bus. I know. Don't know why you're trying to fight it. Just say I've never been on a bus. She doesn't even know if it's a slow bus. Court does call the case, People versus Rahman Mohammed.
My client is not on the bus.
Are you calling him, Mackie?
Lauren Brown, Deputy Chief Public Defender, appearing with and on behalf of Mr. Rahman Mohammed. Mr. Mohammed, please state your name.
Rahman Mohammed. Thank you.
Your Honor, today's date and time set for probable cause conference. We are respectfully requesting that this matter be set for preliminary examination. Also, we'd like to address bond at the.
All right, all discovery is complete.
As far as we know, yeah.
People have their witnesses available the 27th.
We will try our best, I didn't want to let council know Mr. Muhammad has a new warrant in, as of just a few days ago, office received for a fight in the jail apparently, so I'll have that review this month.
Preliminary examination, May 27th, 2025.
Thank you,
9
Honor.
a.m. That's before Judge Fresh Hour.
Thank you, Honor. As to bond.
Yes.
Your Honor, my client is respectfully requesting that the court allow him a personal recognizance bond. He does have a place to stay. He would stay with his father, Kushir Muhammad. That would be in Manor Street in Detroit, Michigan. He's asking if the court feels that it's necessary, he would agree to wear a tether to ensure that he returns to court.
Response.
Your Honor, I think the underlying case, or the case that was set for exam is a bit older, if I'm not mistaken. I'm not sure how much time it came into custody. I am concerned that while he's been in custody, potentially accumulating new assaults and offenses, but I will leave that in discretion of the court. I would request that if he is released, that he is testing, given the nature of this.
And my client will agree to test.
Did he come into custody?
What's your picture?
A traffic stop?
Your Honor, my client tells me that it was a traffic stop.
Oh, Your Honor, maybe approach, please, very quickly.
Approach. Our record should reflect, we've had a bench conference in this case. And in considering everything, I'm going to deny the request for change in bond. Bond will continue.
Thank you, Your Honor.
Thank you. I'm trying to get step over this one. Court calls case People versus Aaron Daniels.
And is on behalf of the people, Your Honor.
And I'm Mackie on behalf of Mr. Daniels, who is to my right. Please state your name for the record. And at this time, we'd like to request that this matter for preliminary examination and all discovery is complete as far as we are aware.
People have their witnesses available the 27th. Preliminary examination in person will be set for May 27th, 2025, 9 a.m. That is before Judge Washington. Bond will continue.
Thank you, Your Honor.
Court calls the case of the people versus Danielle Pressey.
Your children's appearing on behalf of the people.
Michael Gaddy, Assistant Public Defender, on behalf of Ms. Pressey, who's approaching Judge. What's your name?
Danielle Pressey?
Requesting an adjournment.
Yes, Your Honor, there's a lot of discovery to go through.
May 29, 2025, 9 a.m. Bond continue.
If I could be heard on bond, Judge?
You may.
Thank you. Judge, I did have a chance to talk with Ms. Pressey. She is here before the court with a bond of I think it's set at 150,000 cash. This is a situation where she has absolutely no criminal history the last 13 years or so. She does have an old OWI matter from 2012. That's all I could find on her CCH. She resides in the Metro Detroit area in Oxford or Lapeer. She owns a business, a brick and mortar business, a nail salon. She's not a flight risk in any way. She cares for her disabled mother. She is, like I said, gainfully employed. She owns a business, a nail salon that she is the proprietor of. She is. We'd ask the court to consider some kind of a reduction in bond, hopefully a personal bond, like if she would avail herself of any both a scram and a GPS tether if the court thought that was beneficial to ensure both her presence and that she's not anywhere that she should not be. She has, as I said, work, family responsibilities, and have to care for her disabled mother.
Respond.
The facts of this case involve the defendant traveling around 60 miles an hour. It's on Marks Road, which I believe is 45, but it's probably 45 would be my guess. 60 miles an hour with now candidly the BAC was 0.038, but there was also 200 nanograms per milliliter of amphetamine, as well as THC, 2.7 nanograms of THC in her system. The victim is tragically the defendant's son, I believe was 7 at the time. He was improperly belted in the rear seat and killed in the accident. The vehicle crashed into a tree. Based on those facts and circumstances, I don't believe that the bond is improperly set. I believe that the facts of this case are awfully tragic, but I am concerned about the defendant's potential conduct while out this matter pending given the seriousness.
Yeah, if I might, this is a very serious situation, very tragic. There was, the allegations of the purported Adderall, I believe, was a prescribed drug. As Mr. Childers stated, it was a 0.038 of what was the reported drug or alcohol. This was, like I said, this was a situation where I don't think she comported herself. This accident happened several months ago. She's comported back in December, I believe. She's comported herself properly since then. She'll continue to do so. As I said, she's not a flight risk in any way. And she does have responsibilities while we, there's a lot of information to look at here. And I believe this is a matter that is going to be litigated pretty heavily. So I'd ask the court to reduce the bond.
Motion for bond reduction is denied. the court does consider the defendant a risk to public safety. And so her bond will continue. Thank you.
Thank you. Your Honor, if we did put together a written motion, would the people waive notice on that?
No, I'll wait notice as long as you don't give it to me at the end of the day on Wednesday.
No, I don't do that. Okay.
Yeah, as long as I have a fair amount of time to respond to that.
Court consider hearing it early as well, Judge?
It will. When we receive the motion, Ms. Wagner will be more than happy to give you a date to hear it.
Thank you, Judge.
Court does call the case of the people versus Jordan Dave.
I'm sorry, Judge. I didn't catch the adjourn date. My fault.
29.
Thank you. All right.
Court does call the case of the people of the state of Michigan versus Jeffrey Murphy. Ray.
Good morning, Your Honor. May it please the Honorable Court, David Burgess on behalf of Mr. Murphy.
Marie Tanha, aka the phone.
Again, Your Honor, I apologize. Someone dared call my work cell.
What? Somebody called your work cell? I think it was somebody over there. They just. All right. Okay, what are we doing? Your name, sir?
Jeff Murphy.
Thank you. What are we doing?
Your Honor, discovery is complete in this matter, requesting an exam be held.
No. People have their witnesses available the 27th?
Your Honor, if I may have a moment.
Yes.
Your Honor, I do want to bring up something else that's concerning this case, and at this point, I'm hoping that the court can warn the defendant. I'm sure Mr. Burgess will speak to him as well. Part of this case is defendant posting naked pictures of the victim. Not that they should be anywhere, but certainly places that have put her at risk. They have since been taken down, is my understanding. So if the court wouldn't mind issuing a warning to the defendant about ensuring that does not happen again. And I believe Mr. Burgess is well aware of what I would do if this happens again, so he can have a conversation with his client about.
All right. So these came up after the charges in this case?
Let me double check. Your Honor, we don't know the exact date. I have to look into that.
Okay, but they have since been taken down.
Yes, it's been taken down, which is why I'm asking for a warning as opposed to.
All right. You understand that, sir?
Yeah, yes.
All right. And Mr. Burgess, you're gonna have a more detailed conversation with him about that?
Yes, I will, Your Honor. I'm well aware of what Ms. Tanner will do if that's the case. If he does it again, if it happens again, if it did happen in the first place, Your Honor, so.
All right, very good. Okay. And with the people
That's a good date, Your Honor.
that will work,
Thank you, Your Honor.
preliminary examination in person, May 27th, 2025, 9 a.m. That is before Judge Washington. Bond will continue. Thank you. Let's call the case of the people versus Frank Clark.
Okay, I'm sorry, Your Honor. I apologize. Can we recall that previous case? Apparently I wasn't clear,
Okay,
if you don't mind.
you weren't clear? Okay. I guess, can we get him back?
If your defendant feels it's appropriate.
Court recalls the case, people versus Jeffrey Murphy.
Frank has the prosecuting attorney about the people.
Good morning, Your Honor. Again, may it please the Honorable Court, David Burgess on behalf of Jeffrey Murphy.
All righty, thank you for coming back, Mr. Burgess.
Yeah, of course,
Yes.
Your Honor.
Thank you, Your Honor, for recalling the case, and thank you to Mr. Burgess for jumping back on. Mainly, I want to make sure the defendant's not confused about how this process is going to work and what his bond conditions are. The victim was present here today in the gallery, and defendant decided it was a good idea to mean mug her as he walked by her. Here.
Sir.
Now, I know that this defendant has a history of abusing women sexually and physically, and apparently somewhere along the way, he has learned and decided that intimidating a victim of his crime is a good idea. Like I said, I think he's confused, so if we can clear some of that confusion, I would appreciate it.
All right. So you understand that? That you're not, and when the court is saying no contact, no intimidating or threatening behavior, that applies both here in this courtroom and all of your behavior. You understand that, sir?
Yes.
And so if the alleged victim is present in the courtroom, I don't want you staring at them any kind of way.
I got you. I apologize.
All right? All right. Thank you. Thank you, Mr. Burke.
Yes, of course, sure.
Court does call the case People versus Douglas Hill.
Thank you, sir.
On behalf of Mr. Hill.
Got a problem. All right.
Pull them up.
Yes.
You're good. They gotta cover your butt. You don't want to see it.
Okay.
Thank you, Your Honor. I did provide the court with a clean sheet. We're simply asking for a brief adjournment in this case.
If I were to test your client, will you test clean today? And I don't like being lied to.
Probably not.
Okay.
What would be in your system?
I've been tested dirty for cocaine and THC, I believe.
3 successive occasions. Mr. Allen. I found violation report here.
But I haven't even been out a week to get my system clean. I just caught this charge and the bond was just set, so I haven't had time to actually get my system clean.
I have a whole week of testing with cocaine in your system.
We also have a failure to appear for CCOP, is that correct?
For CCOP, what's that?
It's
true.
correction stuff.
No, oh yes, they rescheduled my appointment for Monday at 9:30 with the brown guy for the outpatient program.
Yeah.
That yes, because I thought I showed up at 2, it was at 1:30, and then I also dropped yesterday.
Why is cocaine still in your system?
It will not be today.
Well, you just told me it was gonna come back.
Because I haven't dropped clean yet, that's why I assumed that. I don't know how long it takes to leave.
You're
my system.
still using.
No, I'm not.
No, because you want, okay, I'm gonna tell you what, if you're telling me you're not, I'm gonna take you back, I'll call over, get levels, and then we'll see exactly what's happening.
So I gotta.
You want me to do that?
So I can drop today?
No.
I'm sorry, I
You
didn't.
would go back there with my bailiff, I will call over and get levels. If you're telling me that your system is just cleaning out.
My system should be clean.
No, that's not what I'm saying. You're telling me you're not using,
Correct.
right?
Yes.
Okay. Then this must be some super duper cocaine.
I haven't.
So we'll figure it out. And so what I'm gonna do is, Mr. Allen, you can take him back. We will call over to community corrections, get your levels, and then we'll figure out what's happening. Court does call the case People versus Davian Thomas.
We're ready in that matter, Your Honor.
Andrew Childress, appearing on behalf of the people.
Lauren Brown, Deputy Chief Public Defender. Their opinion with and on behalf of Mr. Davion Thomas. Mr. Thomas, could you state your name for the record?
Davion Thomas.
We're doing the plea.
Yes, please.
The plea form indicates the defendant will be pleading guilty to an added count 3 of larceny by false pretenses, 200 to 1,000 to 1 year offense. Upon his successful plea to that charge, counts 1 and 2 would be dismissed, and it is okay for him to seek hideout in the case. That's the agreement of the parties as the court understands it.
That is our understanding, Your Honor.
May I have him sworn?
Raise your right hand. Do you solemnly swear and affirm the testimony you're about to give be the truth, the whole truth, and nothing but the truth, so help you God?
Yes,
State your name.
Davion Thomas, Your Honor.
Sir, it is this court's understanding that you're going to be pleading guilty to the charge of larceny by false pretenses, $200 to 1,000. That is a misdemeanor punishable by up to 1 year incarceration, a $2,000 fine plus court costs. The fine could be increased at 3 times the value of the property. If it 3 times the value of the property, which is the subject matter of the theft. If that's greater than $2,000, that would become the maximum fine. You understand that?
Yes, Your Honor.
You understand also, sir, that while I'm taking your plea, I would not be your sentencing judge. You would be sentenced before Judge Barr in the 14A2 court. Do you understand that?
Yes, Your Honor.
All right. Now, understanding all of that, do you still wish to plead guilty?
Yes.
Yes. And to that charge, how do you plead?
Guilty, Your Honor.
You understand that by pleading, you will not have a trial? Okay.
Yes, Your Honor.
Did you sign an advice of rights form?
Yes, Your Honor.
All right, approach. Yes. Signed an advice of rights form. Do you have any question regarding those rights?
No, Your Honor.
You'll see a copy on the podium. Please look at paragraph 5. Those are your rights which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes, Your Honor.
You understand you're giving up your right to appeal of right?
Yes, Your Honor.
Are you on probation or parole?
No, Your Honor.
Has anybody promised you anything other than what's been stated here today on the record to get you to plea?
No, Your Honor.
Anybody threaten you or coerce you?
No, Your Honor.
You're doing this voluntarily?
Yes, Your Honor.
Of your own free will?
Yes, Your Honor.
And because you believe that you're indeed guilty of these offenses?
Yes, Your Honor.
On between the dates of January 22nd, 2024 and January 31st, 2024, at the location of Eastern Eateries on the EMU campus, Eastern Michigan, Washtenaw County, state of Michigan, what do you do that makes you think that you?
Yes, what did you do? No, we're talking.
I used cars without permission, Your Honor. So
what kinds of cars?
I had used someone card without their permission
To get food.
To order a DoorDash, which was $40, and I was wrong, Your Honor.
All right, so you did that. And the value, and in using these cards, the value of the property that you received, was that in excess of $200?
No, Your Honor. It was.
Your Honor, I'd be asking the court to take the plea
To the higher charge for that. All right, and the court can do that. And you didn't have anybody's permission to be using these cards?
Correct, Your Honor.
All right. All right. Counsel, have I complied with the court rule?
Defense is satisfied, Your Honor.
Court will accept the defendant's plea guilty to count 3. Counts 1 and 2 are dismissed. Pre-sentence investigation and report is ordered at 14A2 probation. Sentencing in this matter will be
May 28th, Judge Barr at 10 a.m.
May 28, 2025. What time? Time?
10 a.m.
10 a.m. before Judge Barr.
Your Honor, may I address the issue of bond?
Go ahead. Everybody else has some.
Your Honor, my client has, originally he was not incarcerated. The court put him on, I believe he missed the court date. I think he had taken a trip, a family trip. He had taken a family trip. He was able to do that, but he wasn't able to make it into the next court date. I believe that's how the case went.
Yes.
So as a result, the court put him in. We're asking that now that he's pled to the misdemeanor, this is a property offense. My client is scheduled to start his classes on May 19th. We'd ask that his bond be reinstated. He be allowed to be released from incarceration at this time.
So is he gonna be at EMU?
Macomb Community College.
Okay, so how do I know that he's gonna get back here?
Oh, he'll make it back.
Huh?
He'll make it back. He has not enjoyed his time in the Washtenaw County Jail.
Okay, so how did he come into custody?
I turned myself in, Your Honor.
You turned yourself in where? Here?
Yeah.
So he knows how to make it back here, Your Honor.
Any response from the people?
No, I would agree. I believe the defendant appeared in front of you back on May 1st and he was remanded.
Got it. That's what okay. So you know the importance of showing up now?
Yes, Your Honor.
You ever been in jail before?
No, Your Honor.
So this has been Mr. Brown's right. This has been an experience for you.
Yes, Your Honor.
Meaning you take it serious, right?
Absolutely, Your Honor.
I'll reduce the defendant's bond. I'll set it at $25,000 personal recognizance bond.
Thank you.
Thank you. Where'd Cannon go? Okay. About to call her client back up. Court does recall the case, People versus Hill.
I think there was nothing for the people.
Well,
Yes, Your Honor, we did receive the results in this matter and I have discussed them with my client. And what the likely outcome will be based on that result.
Pardon?
And what the likely outcome will be based on that result.
Well, just so the record's clear, he had indicated to me that he hadn't taken it, hadn't been using, but his levels started out in May, or cocaine started out on May 7th at 424, then went down by May 9th to 353, but then by the 14th shot up to 889. So anything else you want to say? He's been using.
Your Honor, my client is just asking for a 1-week adjournment in this case. We're gonna have him screened for drug court to see if that's a suitable, a good fit
Probable
for him.
cause conference will be adjourned May 29th, 2 weeks.
2 weeks. Thank you, Your Honor.
Absolutely. 2025, 9 a.m. His bond is revoked.
And Mr. Hill?
Court calls the case, People versus Martez Dalton.
Rachel McDuffie for the people.
And Maggie, on behalf of Mr. Dalton, who is hearing to my right, Your Honor.
Your name?
Martez Dalton, sir.
I told you he was on the bus. I told you you'd get here, Miss Mackey. They didn't have any faith in you. I had all the faith in the world you were gonna get here.
Your Honor, I want to thank you for passing on the matter, allowing me time to get here, sir, in the time of the matter.
You know what? I had to pass it because she was just screaming at me.
Sir, I don't make no
Miss
excuses.
McDuffie wanted a bench warrant. I had faith in you, and so we gave you time.
Thank you, Your Honor. Thank you, Your Honor. I appreciate that. I was coming. I wasn't in the
No,
midst of anything.
I appreciate you going through the effort to get here, sir. I really.
Your Honor.
All right, and you're requesting an adjournment?
Yeah, Your Honor.
All right. Grant the adjournment. What are we trying to do in this? Oh, okay, I got it. All right, so probable cause conference May 29th, 2025, 9 a.m. Bond continued. All right.
Thank you, Your
Thank you, sir.
Honor.
Yes, sir. Thank you, Your Honor, once again.
Thank you. Oh, that ended on a happy note for Miss Mackey, didn't it? Shocking. What? I didn't see that. Do you put a photo of a bus? Let me see. You drew. I asked for a picture, not like this. Thank you, Miss Mackey. Technically, it is a picture. All right, we'll stand in recess. We'll come back and set our next block shortly. Court stands in recess.
All right.
Court does call the case of the people versus Latrice Lee.
Michael Gash is tender for Ms. Lee, who's approaching, Judge. Yeah, if I could approach, I do have an advice of rights and a sentencing judge waiver.
Okay.
State your name, mister?
Latrice Lee.
I don't care. And
Oh, I'm sorry, Judge. I
don't have a care.
Yes.
Oh. Okay. What's he doing?
I was signing. My apologies, Judge.
All right, I have a plea form that indicates that the defendant will be pleading to the stated count 2 of operating with a high BAC, as well as count 3 attempted resisting and obstructing. The operating with a high BAC is a misdemeanor punishable by up to 180 days in jail, and the other offense up to 1 year in jail. Upon our successful plea to those charges, count 1 would be dismissed. That's the court's full understanding of the.
That's correct, Your Honor.
That is a correct recitation, Judge.
All right, before I take the plea, though, we have a violation.
Oh, I didn't know. May I approach?
May I approach this way, Your Honor?
Yes.
Violation.
There we go off. No, you know what? No, never mind. No, it's in the wrong file.
Oh, that's a video.
It's in the wrong file.
Thank you.
It's okay. It was somebody else's violation.
Okay, I know, I'm,
But you look shocked?
huh,
Never mind. All right, may I have her sworn?
Raise your right hand. Do you solemnly swear to affirm the testimony you're about to give be the truth, the whole truth, and nothing but the truth, so help you God?
yes,
State your name.
Latrice Lee.
And is she pleading guilty? or-
She's pleading no contest, Judge. I did provide the police report yesterday.
Yes, I have the police reports. I just don't. Alan? Am I in
It must
danger?
be working.
No, am I in danger? Are you sure? Are you just telling me?
Oh, wow.
So you're gonna plead no contest. Any admissions.
What?
So,
But that doesn't mean it went away.
Felon.
Shouldn't somebody be checking that?
don't look at me. He pointing to me.
You tell me, I'm, my faith and trust is in you. If you're telling me I'm okay, I'm okay. Ma'am, it's just court's understanding you're gonna plead to no contest to 2 misdemeanor charges. Is that
Yeah.
correct?
Yeah,
The first one being the charge of operating with a high BAC. That is a misdemeanor, which is punishable by up to 180 days incarceration, up to a $700 fine plus court costs. The court could order community service and any rehabilitative programs the court deems necessary. Court could order your vehicle immobilized, could order you to pay the cost of the prosecution as well as the cost of any emergency governmental services. You understand that?
yeah,
The other charge is the offense of attempted resisting and obstructing. That's a misdemeanor, punishable by up to 1 year incarceration and a $1,000 fine plus court costs. You understand that?
yes,
All right. Do you understand what a no contest plea is?
yes,
2 things about a no contest plea I have to make sure that you understand. The first thing is it means that you're not further desirous or wanting to contest these charges. You understand that?
mm-hmm,
Yes?
yes,
All
yes,
right. The other thing that you need to understand is that for purposes of sentencing, the court will treat you the same as though you had pled guilty. You understand that?
yes,
All right. You also understand, ma'am, that while I'm taking your plea, I would not be your sentencing judge and you would be sentenced before Judge Barr in the 14A2 District Court.
yes,
You understand that?
yes,
All right. Basis for the no contest plea.
Potential civil liability, Judge.
Ma'am, to the charge of operating with a high BAC, how do you plead?
guilty.
You plead no contest.
Oh, no contact.
To the charge of attempted resisting and obstructing a police officer, how do you plead?
No contact.
Now, you understand that by pleading no contest, you will not have a trial of any kind.
Yes,
You signed an advice of rights form, is that correct?
yes,
Any question regarding any of those rights?
no,
All right. Please look at paragraph 5. Those are your rights which are part of a trial. And by pleading no contest, you're giving up those rights as well as all the rights on that form.
yes,
You understand you're giving up your right to appeal of?
yes,
Are you on probation or parole?
no,
Has anybody promised you anything other than what's been stated here today on the record to get you to plea?
no,
Anybody threaten you or coerce you?
no,
You're doing this voluntarily and of your own free will?
yes,
Court has been provided and has reviewed Washtenaw County Sheriff's Office report for their case number 24-81414. Any objection to the court having reviewed those reports?
None from defense.
Based on the court's review of the report, the court does find that there's a sufficient factual basis in which the court could determine the defendant's guilt of these offenses. Counsel, have I complied with the court?
I think we're satisfied.
Defense is satisfied, Judge.
Court will accept the defendant's no contest pleas to counts 2 and 3. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 14A2 probation. Sentencing in this matter will be
June 24th at 10 a.m. with Judge Barr.
June 24th, 2025. What time? 10 a.m. before Judge Barr. On will continue.
Actually, if I could ask the court to address the court on a bond condition, Judge.
Yes, go ahead.
Thank you. Ms. Lee has been testing faithfully since the onset of this matter. I think she has had nothing but negative tests. We'd ask the court to remove the testing obligation at this time.
I don't need a response. I'm not going to do that. At this point, her bond will continue.
Thank you, Judge. Thank you. Your Honor.
Court calls case People versus Virgil Stafford.
Brian Bowling on behalf of Mr. Stafford, who hopefully should be on Zoom, Your Honor.
Yes, I am.
State your name, sir.
Virgil Stafford III.
Thank you.
Judge, Mr. Stafford met with the examiner at the Forensic Center on Monday, so we're just waiting that report.
I have this set for a probable cause. Shouldn't be, should it? Huh? I think it should be set for a competency here. All right. So you met with when?
Monday.
9
a.m. Yep.
So let me then set this. We can always move it up, but what I was going is basically to the end of June. Let's see where we are. So June 26th. 2025, 9 a.m. Bond continue.
Thank you, Judge.
Thank you. The court does call the case of the people of the state of Michigan versus Afi Alawar.
Your Honor, Hannah Mackey on behalf of Mr. Alawar, who is to my right. Oh, sorry.
Go ahead, Mr. Drew.
المحكمة تنادي على قضية السيد رافي الأعور وتقول أنه رافي الأعور هو بجانبها.
Your Honor, I'm sorry, I think Hannah may not be hearing or understanding.
Understanding, it's the dialect.
He doesn't understand the dialect.
Is it Lebanese?
This is Arabic. I'm speaking standard Arabic.
Okay. Did you understand?
No.
Maybe you didn't hear him. Maybe he just didn't hear him well.
Okay. سيد عفيف سامعني؟ تسمعني عفيف؟
نعم.
نعم معك مترجم اللغة العربية اسمي حسين.
مش عم بفهم عليك.
He's not understanding. I don't know.
No. To the interpreter, you're indicating that he is indicated to you he is not understanding?
Correct, Your Honor.
Do you know what dialect he needs? Does he need Lebanese?
Lebanese dialect, yes, Your Honor.
He needs Lebanese dialect. Okay. I will adjourn this out to June 5th.
سنقوم بتأجيل الجلسة إلى 5 شهر 6.
9 a.m. and we will seek a Lebanese interpreter.
إلى الساعة 10 صباحا وسنبحث عن مترجم باللهجة اللبنانية.
Okay.
I think he just couldn't hear. I think it was the hearing. It wasn't.
Thank you.
Oh.
I thought the interpreter told me he could not understand.
What he said was like, he just does like, it doesn't mean like actually like understand. I think he just meant like understand, like I can't hear, understand. Like, it's just.
Sir, ask him, can he understand the interpretation in this case?
أنت فاهم الترجمة في هذه الحالة؟
فهمت إنه 5 شهر 6 أجل الدعوة لكذا، هذا اللي فهمته.
Okay. What I understood that the case was postponed to June 5th. That's what I understood.
That what you wish to have happen today?
No, Your Honor.
What?
هل هذا اللي تأمل إنه يحصل اليوم؟
Like شو like what?
يعني إنه تتأجل؟
No problem, yeah. Yes, it's a good.
Okay, what do you wish the court to set?
Set for exam, Your Honor.
What wish the court what?
Could you interpret that they wish to have the matter set for preliminary examination?
هل تحب إنه تكون الأمر يعني يفحص بفحص ابتدائي؟
كيف يعني؟ كيف؟
What? How is that?
I will set this for preliminary examination May 27th.
راح نأجل هذه الفحص الابتدائي إلى يوم 27/5.
And Your Honor, just for the record, we can't help for the people. I don't think we got that.
I'm sorry.
For the record, Marie Tanhoff for the people. I don't believe we got that far initially. Just for the record, my appearance.
Got how far? I'm sorry. You lost me.
Okay, thank you, Your Honor.
All right. I'm going to set it for preliminary examination May 27th before Judge Washington.
Thank you, Your Honor.
And I will send her my best of luck and blessings. All right. Thank you, sir.
Shukran.
Thank you. Thank
All right.
you.
Thank you, Mr. Interpreter.
Oh, anything else you can help with, Your Honor?
No, sir. Thank you.
My pleasure always. Thank you for calling Language Line Solutions and have a good day.
All right.
Thanks, bye.
That's the end of that block. All right.